Thank you both. Here we go. Okay, hello everyone. Thank you so much for being with us today. We are very excited to have you and to be able to deliver this session. My name is Gretchen Shaw, and I am the Deputy Director here at NCADV. We're going to be giving people just a minute or two to log in. We have about 500 people who registered, so that may take a minute for everyone to hop on. So please just bear with me. Making a few last minute changes and we should be good to go. So as you log in, we would love to know where you're from and what your title might be, what the weather is like where you are, if you have any fun plans for the weekend. And please, we encourage you to chat with others and use the chat function liberally throughout this session. Wonderful. It looks like we have people in Texas, Washington, California, Wisconsin, Alabama is my home state, Maryland, Minnesota, North Carolina, Florida, and NCADV. Wonderful. Fabulous to see you all. New York, Pennsylvania, Nebraska, New York. This is so fun. Indiana. All right. So it looks like we've got about almost 200 people on. I'm going to go ahead and start. Again, my name is Gretchen Shaw, and I am the Deputy Director here at NCADV. Today's session is domestic violence and firearms, what happened last week. And this is being co-presented by NCADV and the Battered Women's Justice Project. So we're always grateful to our partnership with them. Our today's speakers are Rachel Graber, who is the Director of Public Policy for NCADV, and David Keck, who is the Director of the National Resource Center on Domestic Violence and Firearms, which is a project of the Battered Women's Justice Project. David, I hope I said that correctly. Okay, wonderful. So before we begin, the questions that often come up are, will this be recorded? Will we receive a recording? Those types of things. So anyone who is attending today or has registered for this session will definitely receive a follow-up email that includes a recording to this session, a link to a downloadable certificate of attendance, and then of course links to any relevant materials. We will also be making this session available for sure via NCADV's YouTube channel in perpetuity, and then the NCADV website. Again, today's speakers are Rachel Graber and David Keck. I will really turn over this session to them here in a few minutes, and let them tell you a little bit about themselves. So Rachel, if you can take it from here.
Thank you, Gretchen. So my name is Rachel Graber. I'm the Director of Public Policy here at the National Coalition Against Domestic Violence. Thank you all so much for joining. I'm going to start with just a little background, and then we will go straight into our agenda. We all know the terrible toll that armed abusers exact on their victims and their communities. Abusers, they use firearms to coerce, to threaten, to injure, and to kill their victims' children, pets, themselves, and others in their communities. 14% of women and more than 5% of men in the United States have actually experienced gun threats by an intimate partner, with more than 40% of women who have been threatened with a firearm also having been injured, whether from a bullet, being pistol whipped, or sexually assaulted with a firearm, or otherwise injured. And we know, of course, that firearms are abusers' preferred murder weapon, with most intimate partner homicides being committed with guns. Research shows the risk of intimate partner femicide increases by 1,000%, that's 11 times, when a male abuser has access to a firearm. And we also know that after decades of decline, the rate of intimate partner homicide has actually begun to increase recently. And this overall increase is due entirely to an increase in homicides committed with firearms. Homicides committed by other means are actually still decreasing. Next slide, please. So here's a very quick agenda. We're going to just start out talking about legislation. This is part of the first part of what happened last week. What happened last week was the Bipartisan Safer Communities Act. What was that? What does that mean? What was federal law? What is it now? At the end of that, we will have just a couple minutes in case anybody has any questions. Then we'll move on to Dave, who will be talking about the United States Supreme Court, some history, and then last week's ruling in the Bruin case. Then there'll be an opportunity to ask him questions. And then if there are any other questions that really don't fit into either of those two sections or that have come up in the meantime, we will just have a final round of questions. Next slide, please. So today I will be focusing primarily on federal law, which provides consistent minimum legal protections for survivors across the country. So, some states and tribes do have laws that are stronger than federal law. Other states and tribes have laws that mirror federal law or are weaker than federal law, or some of them don't have any laws at all. To learn more about laws in your states, very much recommend you check out the website disarmdv.org. Which has summaries of all your state laws. So recognizing the existential threat posed by armed abusers, Congress included a provision in the first VAWA back in 1994, which restricts the rights of respondents to final domestic violence protective orders, their rights to possess firearms, possess, receive, transport, or ship firearms or ammunition. And we call this the protective order prohibitor. Again, it prohibits certain individuals subject to a final protective order from possessing, receiving, shipping, or transporting firearms or ammunition if the protective order was issued after hearing of which the respondent had notice and at which the respondent had an opportunity to appear. So it doesn't apply to ex parte protective orders, only to final protective orders. As you can see from the charts, the protective order must either restrain the respondent from harassing, stalking, or threatening the protected person or the protected person's child, or it must restrain the respondent from engaging in other conduct that would place the protected person in reasonable fear of bodily injury to themselves or their child. In addition, the protective order must either include a finding that the respondent represents a credible threat to the physical safety of the protected person or their child, or it must explicitly prohibit the use or threatened use of physical force that would reasonably be expected to cause bodily injury to the protected person or their child. So you have to have in this chart one from category, one from column A, and also then one from column B. The DVPO, the prohibitor, the protective order prohibitor, it only applies to certain intimate partners. The victim and the perpetrator must either be married or formerly married, cohabiting or formerly cohabiting, or they must share a child in common. So as you can see, it excludes dating partners who don't live together or have a child together. When the protective order expires, the individual is no longer prohibited from possessing firearms due to the protective order. They might still be prohibited for other reasons though. Next slide, please. So that was in 1994. Moving on to 1996. In 1996, in an amendment to an appropriations bill, Congress further prohibited certain individuals convicted of a misdemeanor crime of domestic violence from possessing, receiving, shipping, or transporting firearms or ammunition. This is often referred to as the Lautenberg Amendment after its sponsor, the late Senator Frank Lautenberg, or also we call it the Domestic Violence Misdemeanor Prohibitor or the NCADV Prohibitor. As you know, working with survivors, most criminal cases that result in a conviction for a misdemeanor crime of domestic violence involve felony level violence. But due to the relationship between the victim and the perpetrator, perpetrators are very often given the opportunity to plead down to a misdemeanor crime. Congress recognized that there is this high level of physical violence, and recognized, it should be treated like a felony because they do pose that level of danger. To trigger the federal domestic violence misdemeanor prohibitor, an abuser must be convicted of a misdemeanor crime under federal, state, tribal, or local law. And that crime has to have as an element either the use or attempted use of physical force or a threat with a deadly weapon. So it doesn't have to be called under like state law, tribal law, local law. It doesn't have to be called domestic violence necessarily, but it has to have one of these elements. And then there's also a relationship requirement. If the conviction is expunged or set aside, the individual was pardoned or they had their civil rights restored, the prohibitor no longer applies unless the pardon, restoration, expungement, etc., specifically stipulates that the individual is still prohibited from possessing firearms. So I mentioned the relationship requirements. So until Saturday, this past Saturday, the relationship requirement was very similar to that of the protective order prohibitor in that it only applied to current or former spouses, current or former cohabitants, people who share a child in common, parents, guardians, or people similarly situated to parents, guardians, or spouses. So again, until Saturday, the misdemeanor prohibitor excluded dating partners who have neither cohabited nor share a child in common. Next slide, please. This brings us to the dating loophole. As originally enacted, as we just learned, neither the protective order prohibitor nor the domestic violence misdemeanor prohibitor covered dating partners who have neither cohabited nor share a child in common. And so this loophole allowing adjudicated dating abusers to possess firearms under federal law is often called the dating loophole, or very frequently you'll hear it referred to as the boyfriend loophole. So back in 2006, Congress recognized that dating abusers pose the same risk to their victims as spousal abusers do, and added dating partners to the interstate crime of domestic violence, and also throughout VAWA and throughout FIPSA. In fact, most homicides are actually committed by dating partners rather than spousal abusers. However, until last week, Congress refused to take action to expand that to the Federal Firearms Code. So the Bipartisan Safer Communities Act, which passed Congress last week and was signed into law on Saturday, narrows but does not close the dating loophole. I know there's a lot of confusion about this. A lot of media outlets and politicians are erroneously claiming that the gun package closed the dating loophole. So I'm just going to say that again for emphasis. The Bipartisan Safer Communities Act narrows, or you could say shrinks or partially closes the dating loophole, but it does not close it. Next slide, please. Let's talk about what it actually does do. The Bipartisan Safer Community Act is a very important first step in closing the dating loophole. It adds current or recent former dating partners to the definition of a misdemeanor crime of domestic violence, meaning that it closes the dating loophole for the misdemeanor domestic violence prohibitor. This is really huge. I do not want to understate this. It not only means that, that dating violence misdemeanants won't be able to access firearms. It's also a really important public recognition by Congress, both that, yes, dating violence is just as serious as spousal abuse, and also that this is not an intractable issue, right? We have been fighting to close this loophole for decades, and this shows that it can be done on a bipartisan basis. Unfortunately, the Bipartisan Safer Communities Act was a compromise bill, and parts of it were very compromising. For example, unlike anyone else prohibited under federal law from possessing firearms, first-time dating misdemeanants automatically have their firearms access restored after 5 years under the federal law if they are not convicted of another offense involving physical force or a threat with a deadly weapon in the interim. So we've had the good, which is it closes the loophole for the misdemeanor prohibitor. The bad, that it automatically restores firearms after 5 years. The ugly, it also creates new terminology without definitions that require rulemaking by DOJ. So it has words like recent and continuous and serious that really have no actual meaning in law. And so the introduction of these terms was more intended to be performative than substantive. It's really just to reassure people that, if you go on one date, you beat up your date, you're not going to lose your guns. I think we would all agree that there's a problem there if you're going on one date and beating up the person. But, in those cases, this law, doesn't apply. But, with these new terms and without proper guidance from DOJ, courts may struggle with effective and consistent implementation. So that is the ugly. Next slide, please.
Sorry, I'm going to pop in just 1 minute. A few questions are coming in. Would you like me to read those out, or would you like to watch the chat as they come in?
So Nikki, recent isn't defined. That's part of the problem. Why don't, if we could just keep going, and then there will be time at the end, because, for example, that recent defined, that is kind of part of one of my further slides. So if we could just get to those later, that would be great. Okay, so as far as what the Bipartisan Safer Communities Act does not do, it does not close the loophole for domestic violence protective orders. And this is a biggie, right? No one actually knows how many protective orders are active at any one time. That just information is not available, but we do know that there are a lot more protective orders than misdemeanor convictions. Under current federal law, a dating abuser subject to a final protective order issued after a hearing at which they have an opportunity to appear can still have a firearm, even though court has found that they represent a direct and imminent threat to the victim. This is a really gaping, huge hole, right? And that is why we are consistently emphasizing that the gun package shrank, narrowed, but did not close the dating loophole. We still have a ways to go, and we do not want people to get complacent and think that it's all taken care of, because it's not. Also, unlike all of the other prohibitors, there's actually a start date for the domestic violence misdemeanor prohibitor for dating partners specifically. For all other prohibitors, including domestic violence misdemeanor prohibitor for spouses, etc., it doesn't matter when the adjudication occurred. It only matters that they have the status as having been adjudicated that way, thus. But for dating partners, the prohibitor only applies for convictions after the date of enactment, that is, convictions after last Saturday. And then also, as previously discussed, first-time offenders who don't reoffend get their federal firearms rights restored after 5 years. Just as a point of clarification, this does not restore rights under state law, right? Any restoration of rights due to a state prohibitor has to be done by the state. The federal government does not have that authority. And then again, the federal restoration, it only applies to dating partners, not to spouses or anybody who is prohibited prior to last Saturday. Next slide, please. So I apologize, this slide should actually say regulations, not guidelines. Just talking about our next steps, we are preparing to engage in administrative advocacy to urge them to engage in rulemaking ASAP, and to develop their regulations in a way that ensures that the way that it is implemented is really responsive to the way that people that dating relationships actually appear in the lives of survivors. And that includes survivors across the lifespan, because we know that dating among, 18-year-olds may look very different from dating among, people in their 20s, 30s, 40s, 50s, 60s, 70s, 80s, and older. The dating patterns are changing. And that's why, we need, especially, looking at those terms like serious, like recent, that don't actually have meanings until DOJ or a court gives the meanings to them. And it's so important that DOJ gives those meanings to avoid just absolute chaos at the child court level. We are also not going to let up on lobbying Congress to add dating partners to the domestic violence protective order prohibitor. We need to fully close that loophole, not just partially close that loophole. And then, this isn't something that NCADV does, but we encourage everybody who works at the state level to engage in state level advocacy, because as I mentioned at the very top, states also have laws addressing abusers' access to firearms. And we very strongly encourage everybody to work with their state legislators to close these loopholes at the state level, as well as to develop and implement policies and protocols to ensure that prohibited abusers actually get rid of their firearms when they are prohibited. So that is a very, very quick overview of current federal law, of gaps in current federal law, of what happened legislatively last week. And so we can go to the questions. I see two questions, one from Palma, and I'm going to actually suggest that we wait until after Dave gives his section to answer about SCOTUS ruling. And if you're Palma, if you're thinking about West Virginia versus EPA, we have done a lot to try to establish legislative intent that DOJ issue that rulemaking. There is information, or there was a colloquy in the House specifically to get that on record. So if that's what you're talking about, West Virginia versus EPA, we're hoping that we have, that legislators have created enough of a clear intent for DOJ to do rulemaking. We shall see. The best way to find state prohibitors, I would recommend checking disarmdv.org. It has state-by-state information. I do not know if we've actually updated it yet with the new federal law, but that is coming. Those updates are coming as well. As far as resources, we will be putting together a fact sheet. We have put out some statements. I'm sure BWJP has as well. We would definitely recommend you check out our websites. Let's see, were there other questions, Gretchen?
Let's see, there's one. Did you answer the one on state prohibitors?
To check Disarm DV.
Gotcha. Okay. And then there's one from Lauren that says, I know funding from the Bipartisan Safer Communities Act can be used to help states implement red flag laws. Can that funding be used to implement and enforce firearm surrender in DV criminal and civil cases?
Lauren, I will pull up the statute and read it really quickly while Dave is talking, and I will get back to you. I honestly do not recall. Part of that, again, will be, up to the administration and how they are, how they structure those grants. But I can take a look and get back to you before the end of the webinar.
Okay, thank you, Rachel. Before I start in on the Supreme Court, I just wanted to make one quick comment regarding the boyfriend loophole and protection orders. I think we should all remember that half of all intimate partner homicides are dating relationships only, which means they don't have any other of the traditional sort of domestic relationships. So that's a very significant number of people that remain unprotected. So I think it is important that we look to close that probably bigger loophole than the misdemeanor crimes of domestic violence. So that having been said, I'm here to talk today about the sort of the history of behind what happened last week and what some of my thoughts are. So New York State, can I have the next slide, please? Versus Bruin is the first case to come up to take up the Second Amendment, but the Supreme Court's taken up in many years. The Second Amendment doesn't have a really lengthy history of Supreme Court decisions. There's I got these up here for you to take a look at, but the federal courts have consistently followed, the Supreme Court along the same lines. Supreme Court, at least up until recently, has always just found that the purpose of the Second Amendment is to provide firearms for a militia, as stated in the Second Amendment, and that was the law here up for about over 200 years until 2008, and that was the Heller decision. If we have the next slide. So Heller completely diverged from that. What after 200 years had been sort of a traditional interpretation of the Second Amendment. It applies to the militia. It doesn't mean any more than that. And like I said, that was settled law, and courts followed that, and even including all of the Gun Control Act of 1968 and all through the work that we do, helping people or communities remove firearms pursuant to either federal or state law. That, like I say, was settled law until Heller. And Heller, for the first time, comes to the conclusion that the Second Amendment includes the right to defend yourself, use the firearm for self-defense in your own home. I'll come back to this language here at the top. They talk about, what Heller doesn't do is Heller doesn't impact the right of law-abiding, responsible citizens to use arms in defense of hearth and home, which is what the language they came up with. And it's interesting that they did that because, like I say, for our purposes, it looks like statistically, a firearm in the home, particularly for women, increases the chance of lethality. The accessibility of a firearm alone when there's domestic violence, but it's the firearm in a home itself is statistically more likely to be dangerous to women, particularly who live in that home. And so I am particularly disturbed by this hearth and home language. It isn't traditionally probably the safest place to have a gun, but that's where we are with this. And I can talk about Heller a little bit more in just a second, but I want to also then point out that 2 years later, McDonald versus Chicago, essentially a very similar issue, but then held that it also applies to the states, which is how we come to Bruin, which is, I think, one more slide first. So what the court did in Heller was very interesting. Not only did they add in this or bring up this hearth and home concept, it's just an inherent right to have a gun to defend hearth and home, but at the same time, they very quickly dispatched the first part of the Second Amendment. And I've put a red line through it for dramatic purposes. They didn't literally cross out the first clause, but they effectively did. And they did it without a lot of analysis and really not a lot of discussion. But the majority court in Heller, when they were giving down the decision, they termed this first part, a well-regulated militia being necessary to the security of a free state, is just prefatory language. I'm not a constitutional scholar, and so I can't really answer this, but at least from my reading, I don't know if anyone's ever said anything else in the Constitution is just prefatory, but they essentially took that out of the Second Amendment. That's prefatory language. The other part is the operative language. So the right of the people to keep and bear arms shall not be infringed. Coincidentally, this is the portion of the Second Amendment that for many years, the National Rifle Association, for example, would have that above their door or on their stationery. This part of the Second Amendment, starting with the right of the people to keep and bear arms shall not be infringed, leaving out the militia part. So it was maybe coincidence, but probably not, that they dealt with the militia issue quickly and maybe permanently, unless there's someone can find a way to bring this issue back in front of the Supreme Court. It's the law. So I know this in the last week since this came down, there's been a lot of discussion around the media talking about the use of, how does the militia fill in here? What about those purposes? But I think for legal purposes, that's no longer a viable argument unless you could find a way to get it back in front of the Supreme Court, because the Supreme Court in Heller has ruled that way. Heller, does have, like I said, there are some useful language in there, which is that these longstanding prohibitions are presumptively constitutional. So Heller doesn't disturb any of that. But what it does is very interesting. Because after they sort of dispense with the prefatory language, they apply a historical approach, which is this hearth and home language. So to me, it almost seems like they crossed out some language and put some other in there that wasn't there before. But in any case, now I think we need the next slide, because then we end up with Bruin. Okay, so Bruin, can I see that last slide really quickly? I might have missed something. Was there one in between there? No, okay. Oh, that's it. Okay. So this decision is a very long one. It came out down last week, and I've read it one time. I haven't read through it more than that. I haven't had a chance. It's kind of a lengthy decision, but the first thing that sort of strikes me about it is a lot of it is sort of just history, and not a lot of legal analysis, but just sort of listing how many different courts over the hundreds of years have had come down different ways. So in a certain extent, it kind of is like Heller that way, is a lot of that time spent on it. And it starts out with this very broad, sweeping language that when you first look at it, seems to say there's, the Second Amendment is wide open, and it means everybody can. It really doesn't say that. What it says this is the issue in Bruin, is that the city of New York has, over 100 years, apparently had a requirement that you, to get a concealed carry permit, you had to apply an application, which is looked at, and there's objective standards there. But then they are what has been termed a may issue state, which means that the city of New York still, in a way, retains the authority to deny a permit for subjective reasons. And that's what this case says you can't do. Looks like there's a question about recording. I'm assuming it is, yes, or?
Yes, so a
Okay.
recording and certificate will be sent.
So the narrow issue here really is, and it's kind of interesting because they do an analysis. And they say of the, the 43 states have the shall issue, and only about 6 or 7 have the may issue. So they're saying it's not really a big deal. And if that's all accurate, then it probably won't have a big of impact, at least nationwide. Initially, it's not going to be that that wide sweeping. And I'll give you some other language in a second. But the disturbing thing is in the next slide. This is what the majority opinion, and I think it's Clarence Thomas, I'm not sure, this language kind of toward the beginning of the decision, kind of a whole new standard, because up until last week, you still had that two-part test, the means to end scrutiny if it's something that falls within that protected sphere. So here you've got that being thrown out. Now it's strictly an analysis based on historically, and this is the burden that the government's going to have to meet. According to this, the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. That is a very high burden, I believe. And I don't know if it's a workable one, but that seems to say, unless you've done this before or show somebody else who's done this before, it's been presumptively be unconstitutional. As a question. Okay, this is a very good question. This is about guns on the street and how that might impact domestic violence laws and I guess domestic violence and firearms. That's a really good question. I think that, like I said, we'll go through this in just a second, but I don't think this, at least as far as I'm reading it, is going to be as impactful as we think. But I think it shows what's coming along, and I think this is going to be litigated. I imagine over the next few years. But the concern that we have is always the same, and it's been firearms. First of all, the concept that firearms going to make anybody safer is really somewhat questionable. Whether having a firearm at home is probably something that we would say is statistically not going to be really making particularly survivors of domestic violence that not make them any safer having guns. And so sort of the proposition is the more guns that are on the street, presumably those guns are also being taken home at the end of the day, right? So the more guns anybody has. So on its face, I don't know on the street if that's really necessarily kind of the strongest case for this type of restriction that we're looking at, but it's still, there is going to be a cumulative effect. Here's a comment about shoddy decision. Yeah, I don't disagree with that.
Dave, someone asks if you can clarify what it means, what delimits mean.
My understanding of delimit is designate or unless somebody's got a different, it means determine. From my recollection of what that means, I understand this to mean by putting it on the outer bounds of the right. I mean I don't know what that means, but that seems to be pretty wide open. And the burden, I think, is a very high one, and I don't disagree with the opinion about the decision itself. If anybody wants to Google delimit to see if I'm right or wrong about that. To fix or mark limits, I was close. So if we can have the next slide. Now, this is the reason why I'm not panicking about this is because that I think that first language I think was authored by, I'm guessing was authored by Clarence Thomas, but then some of the concurring opinions when they come out is, I think, kind of reassuring. Galito here says our holding decides nothing about who may lawfully possess a firearm or the requirements that must be met to buy a gun, nor does it decide anything about the kinds of weapons that people may possess. Nor have we disturbed anything that we said in Heller or McDonald versus Chicago about restrictions that may be imposed on the possession or carrying of guns. I think that's very clear language. I think, and to me, that means it's a very narrow decision, which is to say that. So what I take away from that, and I can show you a couple of other concurring opinions that go kind of along with that. What I take away is you can put objective restrictions on who may have access to a gun, but you may not put subjective ones on there. So I think that's what I take away from the holding here, because I think it's one of the next concurring opinions. They even talk about mental health examination, or proving someone's mental health as another one of the criteria for getting this permit. So it even sounds like it would include that. So to me, it wasn't any reason to be too concerned right now. But like I say, I'm very concerned about that broad language that comes in. Can we have the next slide? Because I've got another one. Was there another one? Okay, I guess that was all. So like I say, my takeaway is we'll have to all read it more carefully to see what happens. It was remanded back, and like I say, I'm concerned more about just about that broad language and how that starts showing up in all the work we do.
And yes. I guess there are a couple of things that I do want to add. That historicity test. We know that New York City's law was 110 years old, something like that. It was initially passed in the early 1900s. We also know that domestic violence, the last state law that outlawed it was in the 1920s. So, I think Dave is right that we don't panic, because this is not saying everything goes away. But at the same time, we know that historically domestic violence was not frowned upon, right? I mean, it wasn't illegal in federal law till the 1990s. It wasn't illegal in all the states until the 1920s. And, if we're looking at, pre-antebellum period and British common law in the 1200s, which they did in this ruling, it was expected, probably encouraged in some communities. So I think we are apprehensive, but not necessarily panicked. Is that, Dave, a good summary? Apprehensive but not panicked?
Yeah, that's always been my biggest criticism of Heller, besides all the others, but is really that that focus on kind of what would the colonial man on the street, and it's colonial man, not colonial woman, right? I mean, it's what would the colonial man on the street think was okay? Does he have a concern if a neighbor's got a gun and he terrorizes his wife and girlfriend with it? No, it's not their property, right? Slavery was legal. I mean, why are we looking at that as our standard? And then why are we now throwing it completely to history and not any legal analysis? It doesn't make any sense.
And I think that, Justice Breyer in his dissent made a very compelling point that the Supreme Court, they're lawyers, they're not historians. And also nobody actually knows. We know what was recorded historically, but we can never know for sure what actually was happening in people's hearts and minds. And we also know, who is most likely to be recorded. It's those, in power, not those who are oppressed. And, so the minority and the dissenting voices, who might even have been a majority, but because they had less power, are not going to be those voices that are represented, right? So we're also looking at who makes history and who establishes history and whose history are we really talking about, right?
You're right. This is why it brings out at length. And the other thing that is disturbing is his very first objection is we didn't even have a hearing on this. We didn't even. There's been no record made here, and yet the majority has, like, from my opinion, 3 hours worth of just dates in history, and so that must have come from someplace. But it's not. None of that's in the record. It's very odd decision.
Understandably so.
Nicole, we all agree with you, is what we're saying. Everybody agrees with you.
So to circle back to some of the original questions, so Palm asks, after today's SCOTUS ruling, how effective do you think the regulations will be?
And Palma, are you talking about, just to clarify, are we talking about West Virginia versus EPA? Can you put like in the chat? Yes. Dave, do you want to answer that? I can take a shot at.
I haven't even read it yet, so maybe you should go first. I haven't even read it.
Okay, so I think I think just now we live in a constant state of apprehension, you know, because and I will say that I am not a lawyer. I just took a look at it and I can tell you just from my perspective, but I would also suggest that you consult with Dave after he's read it. You know, but if we're saying that something that is, you know, of great political import or a politically charged notion has to have specific directions from Congress just to engage in rulemaking, you know, I think that is pretty scary, particularly if we're talking again right now about rulemaking pertaining to what constitutes a dating partner. But again, you know, I think we have to see how this plays out, because how a Supreme Court justice interprets things and what vantage point and you know, ideological viewpoint they're interpreting things from, and what the composition of the court is when any specific case gets to it, and which court it gets to, you know, those are all going to influence the outcome of any case. Apprehensive but not panicked. Dave, we're just generally apprehensive?
Yeah, yes. Yes, I would say that's a fair statement. There's a question here about who decides what's subjective and objective. I think the answer to that, and I don't know for sure, but I think the answer is, you know, either you've got those objectives on the criteria written out in paper, and everyone can see whether or not you've met that. But the subjective one would be just sort of like any other reason why, you know, this is denied. That becomes more subjective. So that, I think that's the short answer to that. And there's a question here from Jill about percentage of homicide rises when there are firearms present in a home with DV.
It's 1,000%. I know people have been saying 4 times or 400%, 5 times. That's an old study. That's about 20 years old. And it's what everybody has in their heads because we've been saying it for so often, but there's actually a new meta-analysis of a bunch of studies that came out with 11 times, which is 1,000%.
And remember, you know, how many people are coercively controlled that aren't part of the statistics. So that's another thing to always keep in mind.
Yes, when a male abusive partner, or when a male has access, when a male in general has access to a firearm, doesn't matter who has the gun or who owns the gun or anything like that. If a male has access to it, it increases the risk of intimate partner femicide. So male killing woman by 11 times or 1,000%. And it's on our fact sheets. It should be somewhere on our website, but
Yeah.
I would pull it up and stick it in the chat, but I'm afraid my internet connection will fail if I try to open up anything else.
I'm
Yeah,
trying to do that now, actually. So let me see if I can just share the link to that specific fact sheet. But carry on, sorry.
Thanks, Gretchen.
Any other questions? We'll see what the Supreme Court, well, how that all settles down.
Oh, so back to the question I said I was going to look at. It was about whether the change relating to ERPOs could be used for protective orders. I looked at the actual text. It just really depends on what DOJ decides to do with it. So it actually amends the burn JAG grants, and it does add like civil proceedings writ large to what burn JAG grants can be used for. So it, you know, if DOJ decides that's what it means and goes in that direction, then theoretically it could. But the part specifically talking about red flag laws or red flag laws, which are, I think the preferred term is extreme risk protective orders or extreme risk orders, that explicitly says extreme risk orders, and that would not really apply to domestic violence. So.
Excellent. It looks like questions have slowed down a bit, but we invite people to post any question in chat or in the question and answer section if you still are wondering what else this information means.
So, you know, stay tuned. Depending on how rulemaking goes, we might send out templates and ask everybody to submit, or we might not, just depending on what that process is looking like. And we will continue asking for your support as we push to fully close the dating loophole.
Thank you.
Yes, thank you, everyone. We really appreciate your attendance today. Again, all registrants and attendees will receive an email in about a week that includes a link to this recorded session, any relevant material, and also a link to a downloadable certificate of attendance. So please also take a moment to complete the survey that you'll be prompted for as you close out. Have a wonderful day. Have a great weekend. And Dave and Rachel, as always, thank you very much.
Thank you. Thank you again.
Thanks, Gretchen. Thanks so much, everybody, for joining and for all of your advocacy and support.